The clock is ticking on the next MC Singla hearing at the Supreme Court, and today we're doing a deep analysis of the dilemma faced by the SC as it reviews three potential paths to a judgment and national mandate on pensions and more. I'm Priya Chakraborty and my co-host is Anil Agrawal.
Our deep dive of the three High Court judgments from Jaipur, Chandigarh, and Delhi is one of our 4-series podcasts. This first podcast is a deep analysis of all three judgments and their implications for the MC Singla case. The other 3 podcasts will cover each High Court judgment separately and how these might steer the court's decision.
So picture this, years of legal work, hearings, everything leads up to the big arguments in the Supreme Court, and then finally the judges say, okay, we're reserving judgment.
So, right after saying they'll reserve judgment on October 9th, the Supreme Court asks both sides, the retirees, Indian Banks Association, IBA, and the government for something very specific.
Supreme Justices asked for 3 particular High Court judgments from Jaipur, Chandigarh, and Delhi.
These 3 rulings from different parts of the country seem to offer pretty different takes on the pension updation case.
It tells you the Supreme Court is really digging into how these 3 high courts interpreted A. Article 14 of the Constitution, equality before the law, B. Article 21 of the Constitution, right to life, and C. Regulation 56, pension parity, of the Bank Employees Pension Regulations, 1995, before finalizing their decision.
One later but critical development of the MC Singla case is updation and parity of pension with current bank and government employees.
Specifically, benefits were granted to those retiring after November 2002 that the earlier retirees didn't get. They argue this creates 2 classes of retirees, which they say is unfair and a naked violation of Article 14 of the Constitution.
Okay, so that brings in the big legal arguments and points of law that only the justices can answer.
Absolutely leans heavily on the Constitution, Article 14, which is about equality, and Article 21, the right to life, which includes dignity. And then there's a specific rule, Regulation 56 of the Bank Employees Pension Regulations from 1995. That regulation is key to how pensions can be revised.
So, our mission today is clear. We need to get into these 3 High Court judgments, Jaipur, Chandigarh, and Delhi, because the Supreme Court is obviously using them to see the different ways this issue has been handled legally. They need to figure out how to square these divergent, yet well-reasoned interpretations of the law and Constitution to create a consistent precedent.
That moment when the Supreme Court requested those 3 judgments, that is the real pivot. You have the 2 justices, Justice Sanjeev Khanna and Justice Dipankar Datta. They hear all the arguments and said judgment reserved. And then Justice Khanna immediately asks counsel for these 3 judgments from Jaipur, Chandigarh, and Delhi.
And all 3 were speedily submitted the following day, October 10th, by counsel showing the urgency.
But still, why these 3? Why not just rule based on the arguments already made in the Singla case?
Well, it signals something important. It suggests the SC sees the Singla case as having implications far beyond just Mr. Singla or even PNB retirees. They're looking at the whole system, all the public sector banks, or PSBs.
So they want a ruling that works everywhere, avoid different rules in different states or for different occupations.
Precisely. You can't really have pensioners in Jaipur having effectively different constitutional protections than pensioners in Delhi or Chandigarh. They seem to be aiming for a uniform, harmonized doctrine. Consistency.
Okay, that makes a lot of sense. So understanding these rulings is crucial to predicting the final outcome. Let's start with the first one. The Rajasthan High Court, Jaipur bench. This one's from early 2023 and it's described as encouraging for the retirees.
That's a fair description. The case was SBI Pensioners Association versus SBI and others. These retirees were arguing, similar to Singla, that they were wrongly excluded from 100% dearness allowance, neutralization, that's DA, and updation that retirees after November 2002 got. They claimed it violated Article 14 because the award discriminated against older retirees.
And the key here was how the Jaipur court read Regulation 56, They didn't just see it as passive.
No. They took what's called a liberal interpretation. They said Regulation 56 implies banks have an obligation to consider periodic revision, even if the existing agreements, the bipartite settlements, didn't spell out exactly how or when it had to happen.
An obligation to consider. That sounds a bit soft. Did they actually order the revision?
No, they stopped short of a direct order. They directed SBI and the government to consider pension revision akin to CCS pension formula. CCS is the Central Civil Services Pension System.
So why did the judge just say consider? Why not instruct the government of India to just do it? The justice could have issued a writ of mandamus, literally meaning we command, if they felt there was an obligation.
That's the cautious element. The court seems sympathetic to the constitutional argument, but may be hesitant to directly dictate financial policy to the bank and government. Although by pointing to the existing CCS model, they gave a clear administrative path to follow.
So it's like saying, you should do this and here's a template, but not quite issuing a command.
Kind of. It was a strong nudge, definitely leaning towards the petitioners, but it respected the banks and government's role in actually implementing it. It acknowledged the legal rights issue of retirees, but left the how to fix the problem to administrative mechanisms. If we sum this was a boxing match, then clearly, Jaipur judges awarded this round to the elders.
Okay, a nudge, not a shove from Jaipur. The second case, Chandigarh, is the other end of the spectrum to Jaipur. The Punjab and Haryana High Court ruling sounds much more constrained, more technical.
Yeah, that's a good way to put it. This was the All India Bank Retired Officers Federation v Union of India case, decided late in 2023. The arguments were fundamentally the same. Discrimination based on that 2002 cutoff date, needing updation, needing DA relief.
But the outcome was very different. They used the same regulations, 35 and 56, but came to an opposite conclusion.
Well, not exactly opposite on the meaning of the regulation, but on its effect. They agreed Regulation 56 allows the government and the IBA to revise pensions. But, and this is the key difference, they basically said the lack of a formal existing pension revision framework set up by the government or IBA means there's no basis for automatic parity.
Hold on. So the court is saying we agree you might be treated unfairly, but because the bosses haven't created the paperwork or process to fix it, we can't make them. Doesn't that feel a bit like passing the buck? Especially when constitutional rights like Article 14 are supposedly involved?
It can seem that way, but the court's reasoning is based on legal formality.
Their view was that Regulation 56 isn't self-executing. It needs an administrative action like a specific scheme or an agreement to be put into effect. Without that existing mechanism, the judiciary felt they couldn't just step in and create one.
Why? Is that because the justices believe it involves government policy, finance negotiations, things courts usually leave to the executive or legislature?
Right. And because of that formal reasoning, the Chandigarh court expressed sympathy, but importantly did not issue Writ of Mandamus either. And just to remind you listening, a Writ of Mandamus is a powerful court order. It commands a government body or official to actually carry out a specific legal duty.
Correct. And since the Chandigarh court decided there wasn't a clear pre-existing legal duty or framework compelling revision, at that moment, they couldn't issue the mandamus. They basically suggested the retirees should pursue changes through legislation or direct negotiation with the IBA and government.
So a very technical denial, acknowledged the problem but felt powerless to order the solution.
That sums it up well. Restrained and technical. Staying with the boxing match analogy, this was a draw for both sides.
Okay, so round 1, Jaipur supportive nudge, points to an existing model. Round 2, Chandigarh technical restraint says, no framework, no order. Now, path 3, the Delhi High Court. This one sounds like it took a much stronger rights-based approach.
Definitely. This case, All India PNB Retirees Welfare Association v. Zamda PNB, was decided in April 2024. It really shifted the focus. It wasn't just about the rules. It was about the real-world impact. The court used strong language, stating plainly that the gap between active employees' salary and retirees' pensions has grown constitutionally untenable.
Constitutionally untenable, that's powerful. It frames it not just as unfair, but as actually violating the Constitution itself.
Precisely. They explicitly linked the denial of updation to Article 14, calling the different treatment of retirees an arbitrary classification. And crucially, they brought in Article 21, the right to life and dignity. The court was essentially saying that when the economic gap gets so wide, it impacts a retiree's ability to live with basic dignity, which the Constitution guarantees.
And did Delhi just say consider it, like Jaipur did?
Oh no, they went further. They directed the IBA to actively explore an actuarially viable pension adjustment model. This wasn't just a suggestion, it was a directive to find a workable solution.
And they pointed to examples, they cited precedents where the Reserve Bank of India, RBI, and the central government had managed pension updation successfully.
This showed it wasn't impossible. The models exist. This rights-forward approach, backed by precedent, is likely why the Supreme Court found this ruling particularly worth examining. It offers a potential path for a constitutional remedy. Still staying with the boxing analogy, this round was a definite win, a knockout punch possibly, for retirees and the late MC Singla. But there's always a but, isn't there?
Okay, let's bring it all together. 3 high courts looking at basically the same problem, pension disparity for pre-2002 bank retirees, but using the law, especially Regulation 56 and Articles 14 and 21, to arrive at really different conclusions.
It's a fascinating legal spectrum. Jaipur gives the general push, relying on administrative precedent. Chandigarh hits a wall, focusing on the lack of a formal mechanism. And Delhi takes the boldest step, demanding action based on fundamental rights, arguing the disparity itself violates the Constitution. This was a big stick in the hands of retirees.
And it seems the interpretation of Regulation 56 is at the heart of these differences. The Supreme Court is trying to decide, is Regulation 56 a source of authority, compelling consideration like Jaipur hinted? Is it merely permissive and needs prior administrative action, like Chandigarh ruled? Or does Regulation 56, when viewed through the lens of constitutional rights, like equality, right to life and dignity, actually create a duty for the government to act, as Delhi Judgement strongly suggested?
That's the 64 million rupee question, isn't it? Or perhaps the billion rupee question, given the financial implications. For you listening, the real aha moment is seeing why the Supreme Court wanted these specific cases. They neatly lay out the 3 main philosophical paths the court could take: the administrative nudge, the technical refusal, or the rights-based mandate.
Thinking about those paths, nudge, refusal, mandate, which one carries the most risk for the Supreme Court? Why might they hesitate to just adopt the Delhi High Court's progressive stance?
Well, the risk with a strong Delhi approach to the rights-based mandate is that it involves the judiciary stepping quite firmly into what's usually considered administrative territory. Forcing a specific financial outcome, like pension updation, based on a constitutional interpretation of economic disparity, could set a major precedent.
Absolutely.
It could potentially open the door for many other groups in different sectors to bring similar claims about economic gaps, becoming constitutionally untenable. The SC has the power, certainly, to enforce constitutional rights, but it also has to consider the separation of powers, the role of collective bargaining agreements like those the IBA makes, and the practical financial stability of the banks.
So they need to balance the retirees' rights with the potential systemic impact of a very activist ruling. The need to weigh the clear injustice faced by the retirees against the broader implications for judicial intervention and economic policy and the financial health of the PSBs. So, to wrap up, the Supreme Court is using the MC Singla case to weigh up a national standard for pension parity across the entire public banking sector. Judgment was reserved, but asking for three contrasting High Court rulings tells us they are carefully building a uniform, harmonized doctrine, and it suggests the final judgment won't just be a technical ruling on Regulation 56.
Thank you for watching, and please don't miss our forthcoming 3 episodes, one each on Jaipur, Chandigarh, and Delhi judgments.